Good morning, everyone, and thank you so much for your attendance. My name is Becky Page, and I'm president of Human Resources Plus, along with Teresa Friel, who's our HRP senior HR professional. For those of you who are not familiar with HRP, we're committed to providing quality and affordable HR services and guidance, including providing guidance which will help you to help assist you in reducing liability. But most of all, we're very passionate about providing education to all our clients and attendees of the latest employment laws that impact business. One thing we really excel at is taking complicated employment laws and communicating the requirement in a way that's going to be applicable in our clients' businesses. Also, we're very pleased to have again Jennifer Gokenbach as a co-presenter. Her top-rated firm, the Workplace Council, has represented employers from many industries, and she's been a valuable strategic partner of HRP for many years. Keep in mind, we have many different attendees that are from a varied background when it comes to the number of employees and industries, and we'll try to touch on topics that are pertinent to many on this webinar. So we will move forward. So there we are. Okay, housekeeping items. Make sure that everybody mutes themselves. Please make sure you turn your video off. You will receive an email copy of the PowerPoint presentation and the recording. We are recording right now. We do value your time, and we'll have a hard stop at 1 hour. The main thing is as always with the disclaimer, all the information is what we know as today. The information in this presentation is not intended to be or provide legal advice. Clients and prospective clients are urged to seek legal counsel from a competent attorney. You're more than welcome to ask questions in the chat room. We look forward to all your questions. However, keep in mind there's still a lot of unknowns. However, our next webinar is going to be on what they call the ETS, which is the Emergency Temporary Standard from OSHA, which is part of the instruction that President Biden gave September 9th. So hopefully the questions we receive today, we'll be able to answer them and address that in the next webinar. Today, we're going to just do a refresher on the paid sick and public health emergency leave. We're still hearing from prospective clients that they're not realizing that PHE is still in effect and how that PHE works. We are going to talk about the vaccination policies and procedures, which I know is probably going to be of the most interest. And then just talk about COVID-19 prevention response and forms and resources that you need to obtain or create. So I am going to turn it over to Teresa. She is the expert on this paid sick leave and PHE leave. She tends to field most of our questions about that. So Teresa, take it away.
Perfect. Thank you. Thank you. And good morning to everybody. And we do appreciate you joining us this morning. Healthy Families and Workplaces Act. This was actually put into place for Colorado employers starting January of 2021, and that is for employers with 16 or more employees. And what that includes is up to 48 hours of paid sick leave. There are certain reasons that the employee can use for this paid sick leave. I'll mention them now, but we do have a link in the PowerPoint that you can refer to when we send it out so that you can click on that link and see all of this information. But the paid sick leave under the Healthy Families and Workplaces Act does include employees to miss work for mental and physical illness, injury, or health condition, obtaining preventive medical care. That does include going to get the vaccination or a medical diagnosis, care, or treatment, being a victim of domestic abuse, sexual assault, or criminal harassment, and then also care for a family member who has a mental or physical illness, injury, or health condition, and numbers 2 and 3 of what I just read off. Again, as of January 1st, 2021, if you have 16 employees, 16 or more employees, this did go into effect for you. The remainder of the employers of any size, starting January 1 of 2022, you will be required to provide this paid sick leave of up to 48 hours. The paid sick leave is for all employees. So regardless of whether an employee works 1 hour a week or 40 hours a week, they will accrue this paid sick leave starting on their first day of employment. Again, you can refer to more information on the info sheet number 6B on this presentation. And of course, if you have any questions or if you need any assistance creating your policy, if you're due to start providing this leave in January, please reach out and we can certainly assist you with that. All right, Becky, let's move on to the next slide. Okay, public health emergency leave. This started in January of this year. And what that is up to 80 hours of supplemental leave due to COVID-related reasons. They've extended this many times throughout the year. And we do foresee that it's going to go through the year of 2021. So the reasons for the public health emergency supplemental leave are a little bit different, or very different, from the Healthy Families and Workplaces Act. So these are two separate leaves that you're required to provide to your employees. The PHE is for all employers, regardless of size. So even if you don't have to provide the HFWA 48 hours of paid sick leave, you do have to provide the PHE leave. Now, the 80 hours is for employees that normally work 40 hours or more. So it would be less for employees that work less than 40 hours per week. If you need information on that, again, it's located in that info sheet number 6B, which I think is on the next slide, and it'll help you determine your employees that work less than full-time, what hours they would have available. So what happens as we, quickly approach the end of the year? What happens when we move into 2022? Well, we're not really sure at this time. Will the 80 hours transfer over? If somebody's used them, will they, receive additional hours? Unfortunately, this is still unknown to us. The wage protection rules do state that it is a one-time supplement of this 80 hours, but we're not really quite sure what that's going to look like in 2022. The reason for this particular leave is needing to self-isolate due to either being diagnosed with or having symptoms of a communicable illness, seeking a diagnosis, treatment, and care of such illness, being excluded from work by a government health official or by your employer due to an employee having an exposure or symptoms of, or being unable to work due to a health condition that may increase or risk such an illness. It also includes caring for a child other than a family member that are, numbers 1 through 3 that I just read off. Again, this information is in that info sheet number 6B, so you can refer to that. We send out, HRP sends out a monthly newsletter, and we, really, try to make sure that we include any new laws on that monthly newsletter if something kind of comes up. And we feel that it's, urgent to get the information out before we send out the newsletter. We will do a breaking news email. So it is really important that you are signed up to receive our newsletter. When I send out the presentation in an email, I will include a link that you can go in and make sure that you're registered for our monthly newsletter. All right, Becky, next slide. So here's that interpretive notice number 6B, paid sick leave under the HFWA. A lot of really great information in there. So make sure that you do refer to that. However, if you do have additional questions, sometimes it's kind of hard to interpret what they're trying to say. You can always reach out to us. Also, the Colorado Workplace Public Health Rights poster. This is a poster that you should have posted in your place of employment right now. So make sure that if you don't have that you do click on that link and you can print out the poster and get that put up. The Colorado Department of Labor also has the poster in different languages. So if you do need it in Spanish or another language, then you can certainly go there and get that information. Something new that has come up, updated in June 30th of 2021, this year, the Colorado Department of Labor did update the Colorado Wage Act. And this is specific to pay under the Healthy Families and Workplaces Act. And it says, individual liability under this Wage Act. So what does that mean? The interpretive notice does provide an example of what this means, and it goes on to explain that an employee working as a mechanic at an auto body shop could bring a wage claim simultaneously against both the business and the owner who manages the business. If an individual qualifies as an employer, they are personally liable, legally responsible, along with the business for paying any amount of money owed for this wage and hour violation, and that would include any fines and penalties. Again, this is specific to employees that haven't been appropriately paid out for the Healthy Families and Workplaces Act, 48 hours of paid sick leave, and the public health emergency. This information, this info number 11A, this will be a link. So you will be able to click on this when you receive the presentation. And all the information that I'm reviewing will be included in this link. But they do go on to describe what identifies or defines an individual as an employer. And they have 4 basic factors that they're going to use. One being that this individual has the power to hire and fire employees. 2, the extent to which the individual supervises or controls employee work schedules or conditions of employment. Whether the individual determines the rate and method of employee payment, and whether an individual maintains employee records. So if you have a manager that falls under these categories and your organization has not paid out accordingly, that individual can be held liable as well as the business. And that's it.
Great. Thanks, Teresa. I know that's probably quite a shock to a lot of people. And like we said, there's a link in there and you can review it. And probably the best steps is to kind of review your internal processes of who has these responsibilities and are they the appropriate people to have the responsibilities. So that's the end of our portion for the paid sick leave. And I do know that I get questions a little bit about the PHE. Is although Governor Polis has dropped the public health emergency in the state of Colorado, the way the law is written is whether it's local, state, or federal. And we are still under a federal public health emergency. So that is why it has been extended. So now we're going to go to Jennifer's portion, and this is the fun portion, the vaccine policies and procedures. And take it away, Jennifer.
Okay, thank you, Becky and Teresa. Hello, everyone. Thank you for joining us today. I'm going to talk to you about the ever-changing state of vaccine requirements in employment. And this first slide that we have is just more of a general slide in terms of private employers who are looking at adopting a vaccine policy today. So things can change in the future, as you're going to hear, but right now there is an option for generally private employers to decide whether or not they want to have a vaccine policy or not. There are exceptions to that, which I'm going to talk about right now. And I think it's helpful to look at things historically as well as chronologically, just to give you some context as to what's happening in our world with this COVID-19 vaccine and certain state and federal requirements. So what I'll say is, to start out, I think historically it's important to recognize that we have had in the United States issues with vaccines in the workplace going back to the early 1900s. So the first time that the US Supreme Court actually reviewed mandatory vaccine policy in the workplace was in connection with the smallpox vaccine. And that was back in 1905. So in that case that was evaluated by the US Supreme Court in 1905, there was a mandatory vaccination policy for people to be vaccinated for smallpox. And the US Supreme Court found that mandatory vaccination was, in that case, was reasonably restricted, and it wasn't a violation of constitutional rights because it was a public health emergency. So we have that historical precedent going into what we're dealing with now in 2021 and 2020 for COVID-19. Also in 2009, OSHA also required certain employers to require employees to have the H1N1 vaccine, depending on the industry. And that was also held to be a permissible rule implemented by a government agency. In 2012, in Colorado, our Board of Health passed a rule requiring mandatory influenza vaccines of employees in Colorado in licensed healthcare facilities, and that has been in place since 2012. So now fast forward to where we are today with COVID-19. We have had a lot of different rules and regulations come into play for certain employers in Colorado. So for example, in August of 2021, just last month, the Board of Health in Colorado adopted an emergency rule that mandated all employees, direct contractors, and support staff in licensed healthcare settings to be fully vaccinated no later than October 31. And then also after October 31, any healthcare employer in Colorado may only hire fully vaccinated individuals. So if you are a healthcare employer, you probably are already aware of what the Colorado Board of Health has adopted in terms of an emergency rule. But, there may be a question, I guess, for some tangential types of businesses if they are truly a healthcare employer and are covered under this. And so I would encourage any of those folks to make sure they're consulting with HR or legal counsel to determine whether or not they're covered. Why don't we move to the next slide so I can talk about Biden's proposed plan.
It's there.
Oh, I'm sorry. I didn't see that. I was looking at the wrong screen. Thank you. Okay, so just this month, earlier this month, I believe it was on September 9th, President Biden signed 2 executive orders that will mandate vaccines for COVID-19 in the workplace. One order had to do with federal employees. So he's mandating that all federal employees get vaccinated. The other executive order he signed was one to direct the United States Department of Labor, and specifically OSHA, which is an arm of the Department of Labor, to enact a temporary emergency rule to require vaccination in private workplaces that have at least 100 employees. So they're considering that number, 100 employees, to be a large employer, and that being subject to this new directive, if you will, because we don't yet have the rule, we don't yet have any legislation, but this new executive order directive from the president to mandate COVID-19 vaccinations. So any employer, private, who has 100 or more employees needs to be aware that this is going to be put in place, and to keep watching and listening for when it is enacted. I just checked this morning to see if we have the proposed rule yet from OSHA, and I did not see it. So, just keep your ears open and your eyes open for when that's going to come out. But essentially, we don't know the specifics of how do you count employees? Do you count similarly to what we do under the FMLA, which is, within a certain radius, you have to aggregate different worksite locations in order to count? Do you count over a 2-year period? If you have a changing number, or if you're right on the cusp of 100. And so we don't have those specifics yet, but that will be included in whatever the proposed rule is. There are no specifics yet for testing in terms of who's going to be paying for testing. If one of the elements of the new requirement is weekly testing, if somebody isn't vaccinated, who's going to be paying for that? We don't know that yet. Also, in terms of paid time off for this new government regulation, if employers are going to have to pay time off for a covered employee to receive the vaccination and or recover from potential side effects, that is also TBD. What we do know, however, is that this new OSHA regulation will subject employers to OSHA investigations, OSHA citations, and the fine could be up to $14,000 per violation. So it's important when this gets put into place for all private employers who meet the 100 employees or more threshold to make sure that they are following the record keeping obligations, they are following the mandate that is going to come down federally for this vaccination. In terms of Colorado employers that maybe have under 100 employees and are not a healthcare employer, that's where we go back to the prior slide, where those employers can then decide, do we want to have one or do we not want to have one? There is a lot, if you've been watching the news, there is a lot of litigation going on over private and public employers mandating COVID vaccines in the workplace. And We will probably continue to see a lot of litigation over it. But generally, and again, I'm just saying generally, we have seen that none of the lawsuits that have been filed so far have been successful. So they have either been dismissed after a complaint is filed, or they are maybe proceeding forward on a narrow issue. But we've seen a lot of, we'll call them slapdowns from federal courts on these lawsuits that have been filed opposing mandatory vaccine policies. They have come out of Texas, they have come out of California. The big one that was recent was one that was filed by a large group of healthcare workers that were working for Texas hospital system, opposing the mandatory vaccination policy in place. It was the Texas Methodist hospital system. And the federal judge in that case dismissed the lawsuit and issued a rather strongly worded order about the importance of protecting public health when evaluating the constitutional arguments that were being made. So with that being said, employers right now, private employers, are fairly likely to be on firm legal ground if they want to mandate the vaccine. The issue with that, of course, is that practically speaking, if you have people opposing a mandatory vaccination policy, you are going to have to deal with those claims. But at the end of the day, most of those claims are not being permitted. They're getting dismissed, at least by the federal courts. In addition, there has been guidance that has been published by the EEOC earlier this year. The EEOC in May of 2021 updated their own guidance, basically blessing employers to legally require COVID-19 vaccination for employees. The carve out, of course, by the EEOC is that the employer policies must allow for exemptions based on disability or sincerely held religious beliefs, which I will talk to you about on our next slide. So this slide is a graphical representation of how does an employer deal with an employee who has made a request for a reasonable accommodation, either for a disability or a medical condition, or for a sincerely held religious belief. So what I recommend to all of my clients is anytime an employee makes a reasonable accommodation request, you have to evaluate each request on a case-by-case basis. You cannot have a one-size-fits-all policy. It is very specific to the disability that the employee is suffering with, or the religion, or the religious tenets that the employee has subscribed to. So each and every time an accommodation comes up, it needs to be evaluated on its own merits. There is no one size fits all. But essentially, what employers should do is, determine whether or not somebody is bringing to you as the employer an ADA protected disability or a sincerely held religious belief. And the way that you do that is you get a request from an employee, and it's a good idea, and HRP will tell you that it's a good idea to have policies in place about any sort of accommodation requests that your employees want to make. And it's also a good idea to have forms available for your employees to fill out if they are making a request. So that way you can have a little bit more structure around this process, and that you can make sure you're following the recommended steps. But basically, when you get a request for a reasonable accommodation and an exemption from a mandatory vaccination policy in the workplace, it is imperative to engage in step 3, which is the interactive process with the employee. That is where the employer and the employee are having a dialogue. That's what the interactive process is. It's basically where it's communication, a bilateral communication between both sides, the employer and the employee. And it can be totally formal, back and forth in written form, or it can be informal and formal. It can be meetings, it can be telephone calls, it can be emails, whatever the communication means is, it's important to engage in that communication. So what that means is that both parties have to be forthcoming with information and forthcoming with questions. So if somebody comes and says, I want to make a religious exemption, I want to raise a religious exemption to the mandatory vaccine policy, then it's important for the employer to say, okay, well, tell me more about that. Tell me, what is the basis for your religious exemption request? And if the employee says, well, I believe that, my religion says that I should not put something foreign into my body, that's not necessarily enough information for the employer to evaluate it. So what the interactive process is then the employer says, well, I still need to know more. What religion do you ascribe to? What are the tenets that you are referencing? Just so that the employer can evaluate whether or not it is a, quote, sincerely held religious belief. And so that interactive process is the most important part and is a legal obligation for an employer. So again, it's important to do this on a case-by-case basis when a reasonable accommodation request is made. And that goes for disabilities, medical conditions, and sincerely held religious beliefs. So once you get all the information needed in order to do the evaluation, so you get that information through the interactive process, then you need to have people who are going to be making a determination on behalf of the company, whether or not this is an ADA protected disability, whether or not this is a sincerely held religious belief, which also there's a lot of credibility issues in the sincerely held religious belief evaluation. So you need to make sure that whoever's making these determinations on behalf of the company are neutral, an HR department or even outside HR consultants would be helpful in that regard. So that way the company can defend against legal claims and not be accused of discrimination or not complying with their legal obligations. Once that was step 4, determining whether there is an ADA protected disability or a sincerely held belief, then you jump after that to step 5, which is, does this pose a direct threat to others in the workplace, or does this create an undue hardship on the business? And so a lot of times when I work with my clients, they immediately go to, oh, well, that would be an undue hardship for me to do this particular accommodation that is being requested. And I always try to have them step back and say, well, let's not assume that this is a ADA protected disability or a sincerely held religious belief, because we need to do that analysis first. Then we do the direct threat analysis or the undue hardship analysis. We don't go to that next, because what that does is that creates that assumption that this person is already protected under the Americans with Disabilities Act or Title VII, which employers are not serving their interests best if they make that assumption. You need to do both parts of the analysis. And then once you're done with the analysis, then you move on to step 6, which is obviously, again, communicating with the employee and notifying them of the decision. So as we get into these mandatory vaccination obligations that are coming down from both the federal and state governments, and as more and more private employers are going to be adopting vaccine policies, because we're dealing with very nuanced areas of disability discrimination and religious discrimination, it is really, really important to understand the obligations of evaluating requests for accommodation under these nuanced areas in a very structured process, and to make sure you have folks in place that are going to be evaluating requests for accommodations, making decisions on them, and then making sure you're documenting communication with the employee on that, because these are typically the areas that are, they're more challenging for employers to comply with because they are so nuanced and there is no one size fits all. It is a very fact-specific analysis that has to be done. And so highly encourage employers to work with, their HR department if they have one, outside HR folks like Teresa and Becky, if you use them, or if you have legal counsel as well. This is something that I have been working with my clients on since COVID-19 has come about, and just important to get good counsel on it so that employers can make sure they're complying with all of their legal obligations and requirements in this new world that we're in. So the next slide here that we have is, since we're looking at a potential federal mandate for COVID-19 vaccination in the workplace. And again, this federal mandate is going to apply to large employers, those employers who have 100 or more employees, which again, for counting purposes, we don't know yet. That's going to be part of this new rule. Basically, these items on this slide are still to be determined. And so we're going to be watching and keeping our eyes out for what's going to happen with the new OSHA regulations about this new mandate. And so some considerations that would be helpful for employers of all sizes to just be thinking about now as we're getting ready for this federal mandate. Do you have an electronic onboarding system to be able to distribute information to your employees? What system do you have in order to push out information quickly to folks? Who will be the company representative or representatives to handle the administration of the vaccine mandate? It's a good idea now to think about who would be the best people to put in front of this and that are going to be helping you as the employer manage this. It's also a good idea to review your current process for handling religious and medical exemptions, as we talked about on that graphical slide with steps 1 through 6. Also, are there going to be incentives to encourage employees if you don't have a mandatory policy, if you're under 100, if you're not a healthcare employer, but you want to have an incentive to encourage people to comply with the mandate? Right now, you can do that. There's nothing unlawful about that. So consider if you want to have an incentive to encourage it, if you are an employer that wants to have a vaccinated workforce. And then also just looking at your health and safety protocols overall, making sure your workplace is safe, complying with the general OSHA requirements, but are there any in light of COVID-19 that you should add, that you should revise, that you should remove? So just being aware of what's coming down the pike and taking a reasoned and thoughtful approach to what are you currently doing for your workplace and what possibly needs to be updated given this new federal mandate that's coming down.
Great, thanks, Jennifer. And that's going to kind of segue into our last segment. But I do have some kind of questions maybe to bounce off. And I just kind of want to circle back because I know we have some nonprofits and construction companies to the federal contractor requirement. So September 9th, President Biden, issued this instruction to OSHA. And like I said in the beginning, it's called the ETS, the Emergency Temporary Standard. And what I understand about that is that that can be in place for 6 months, and then they do have to replace it with a permanent. But on September 24th, they came out with a definition of what federal contractors are. Like I said, it just came out September 24th, so I haven't had a great deal of time to really dig into this. But they had 4 bullets, and they had the first bullet is a covered contractor is a primary contractor or subcontractor at any tier who is party to a covered contract. Now they refer to the contracts entered in on or after October 15th, whose value exceeds $250,000, 250,000. Also in the bullets, they've identified an employee who works in conjunction with a covered contract when he performs duties necessary to the performance of the covered contract, but who are not directly engaged in performing the specific work called for by the covered contract, such as human resources, billing, and legal review. So one thing I am going to do is I'm sure there's probably some people on the webinar that want to kind of dig into this. And so I'll put a link to the actual White House and the release of the definition of a covered contractor in the PowerPoint before we send it out. And I think that, that's going to be an area that really of this mandatory vaccination, your first question is going to be, am I covered? Period. And like we said, there's going to be additional information coming about how you calculate the number of employees and things like that. So did I get that kind of right, Jennifer? Or is there anything I missed or?
Nope, you got it. I mean,
Okay.
generally what I say, and most people who work in workplaces or work for employers who receive federal funds, you kind of are in that realm of being a general federal contractor. So you're aware of all of the added requirements that you have. But yeah, it does seem that this new definition could potentially expand that a bit. So there could be some new nuances, but you covered it. And stay tuned.
Great. Thanks, Jennifer. Okay, we're just going to move on to some reminders, COVID prevention and response. This is just kind of a graphic. We're not going to spend much time on it, but early in the COVID, we had, encouraged employers to kind of develop a COVID protocol. And we're really circling back to that it should have all these pieces to the puzzle in one document. And we have a COVID business protocol worksheet for our members on our website. We're in the process of adding the vaccination section, and that should be up early next week. Also, we have created a large employer vaccination policy. It's just obviously a kind of a shell, but it'll give you a start. And then when we get more information, you'll be able to plug more information in there. So all of our members will have access to that early next week. But we encourage all businesses to create some kind of inclusive document that talks about all those pieces in that puzzle and how you're handling them. Obviously, everybody's pretty familiar with the steps right now. We're not going to spend a lot of time on this. But one thing that did change since the last time we had a webinar is the quarantine and isolation. Okay. So what they've done is they've split out the fully vaccinated. So you're probably going to refer to this screen a lot. So it's anyone who's had close contact with someone should stay home for 14 days after their last exposure to that person. However, anyone who has had close contact with someone with COVID and meets the referral criteria does not need to stay home. So if someone has been fully vaccinated and shows no sign of COVID-19, they do not have to stay home. However, they're recommending, it says should, the vaccinated people should get tested 3 to 5 days after their exposure, even if they don't have symptoms, and should wear a mask indoors in the public for 14 days following their exposure or until their test result is negative. Or someone that has a COVID illness within the previous 3 months and has recovered and remains without COVID-19 symptoms. So that is definitely a big change from what we've kind of been guided to. And like I said, when you have questions, when you get this, I would just refer back to the slide. Jennifer, Teresa, do you guys have any other input on that?
Nope.
Okay, great. So this goes into it even further. Some questions that we get, I think, or I know I had COVID and I had symptoms. Once again, you can be around others after 10 days since the symptoms first appeared. And remember, it's and 24 hours with no fever, without the use of fever reducing medications, and other symptoms of COVID are improving. It's not or. I tested positive for COVID, but have no symptoms. If you continue to have no symptoms, you can be with others after 10 days have passed, since you had a positive viral test. And if you develop symptoms after testing positive, follow the guidance above. So one note down here is, in the advice from CDC, this doesn't apply to people with severe COVID and with weakened immune systems. You need to refer to the CDC on that. They have specific guidance. So I do have another question that I think is that we need to answer. And like I said, please feel free to submit us any questions through our contact page. But I think another question is that I've gotten is, what kind of tests are going to be approved? You know, there's some at-home tests now, so there's been some confusion of whether they can accept that or not. So I would, anticipate hopefully that those questions will be answered. So Teresa, we got a little bit of time here. Do we have any questions that you want to, from the chat, that you want to address?
Yeah, there are a few. I tried to answer some in regards to the PHE and the HFWA, but there is a question regarding, which I think we covered this after this question was submitted, but what's the difference between incentivized and mandatory policies? But I think that we covered that. So Sharon, if you have any other questions on that, please let us know. Another question, which is probably more for Jennifer, is, do you have to have a vaccination mandate policy in place to ask a job applicant their vaccination status?
So right now, in terms of the federal mandate that President Biden has signed an executive order for, we don't yet have the specifics of what it means to only hire vaccinated people after October 31. We don't know if that means you have to ask, or, we don't have the specifics around that. If you're currently a healthcare employer and in Colorado, and you are covered under the Colorado Board of Health mandate to make sure that all of your employees, your workforce is vaccinated, then it should be part of your onboarding questions or your hiring questions, because you're required now to comply with it. So, but I guess generally, if we're not talking about either a state or a federal mandate to have a vaccinated workforce, if you're just talking generally about, we're a private employer, we don't fall under any of these mandatory policies, but we want to have our own vaccination policy, it is permissible to ask if somebody has been vaccinated, but I would not go further than that in terms of uncovering potential medical or disability information that you don't want to have to then protect under HIPAA and whatnot. So I would think if you are a private employer that is not currently mandated to have a vaccine policy, but you do want to have a vaccinated workforce, it would be permissible to ask applicants if they have been vaccinated, but that would be the only question that I would ask. It would be a yes or no. And then, we would need, again, going back to my initial recommendation, you have to kind of evaluate all of these things on a case-by-case basis. So it would be important to make sure you do a consultation to evaluate what do you do if somebody says, no, I haven't been vaccinated, and they're contrary to what policy you want to have in your workplace. It would just be important to consult with HR or legal on that.
Okay. And I think some of the symptoms and quarantine questions were answered in the following slide after that was asked. Another question is, what if a healthcare employee is refusing to get vaccinated? This is a small office of less than 15 people. What is the best way to handle this situation?
I'm guessing that's for me too.
Yeah.
Yeah.
I mean, I could guess. I think I know where you're going with it, but.
Yeah. So if you have a policy, and in here it sounds like a healthcare employer has to have a vaccinated workforce. If there is a date certain when the vaccination needs to occur, September 30th is actually a date certain for a lot of mandatory policies that are out there for certain employers. And so say, for example, today is the deadline for everybody to be vaccinated. If they don't comply and they don't raise a exemption, a medical or a religious exemption, then you can put them on a leave of absence, you can terminate. But again, these are nuanced questions that need to be evaluated on a case-by-case basis. So you have to, before you take an adverse action against any employee, it's important to evaluate, are they in a protected class? Do they, potentially have whistleblower protections? What other things come into play? So before any employer takes an adverse action, it's important to evaluate the totality of the circumstances. But I can say generally, if you're a healthcare employer, you have a date certain when vaccination needs to be completed and proof of it needs to be provided. And if after that date certain, you have folks who are falling into this bucket of, we haven't heard from them, we don't know what's going on, you can put them out on a leave of absence so that you can evaluate what's going on with them. Or you need to just make sure you approach them and say, this was our date certain, you haven't done it yet, you haven't requested an accommodation, you haven't requested an exemption, we're either going to put you on a leave or we're going to have to evaluate whether or not you're going to be separated. But again, before you take an adverse action, highly recommend consulting with HR or legal counsel.
Okay. Let's see. Does HIPAA play a role in any of this?
Yes, absolutely.
Which I think you talked about that. Yeah.
Yeah. Anytime that an employer is collecting or getting information that deals with any sort of medical issue of an employee or any sort of disability issue, HIPAA comes into play. And it's really, really important for employers to recognize that and to make sure they're protecting all of that data and information that is highly confidential. So a good rule of thumb that is also required by both state and federal record keeping laws is that employers might have personnel files for each employee that has everything from, their tax forms to their application for employment to, discipline to performance reviews. They'll have that in the personnel file. But anytime you have medical or disability issues, those need to be maintained in a separate medical file for that employee. So again, that's a record keeping obligation, both state and federally, that employers can have personnel files with general personnel information, but anytime you have any sort of medical or disability information, that also needs to be maintained in a file for that employee, but it needs to be in a confidential medical file that's separate and apart from the personnel file so that you are complying with HIPAA obligations.
Great. Thanks, Jennifer. Well, we're coming to the we would love for you to give us your feedback on the last slide. There's going to be a link. Because of this new individual liability that went into effect on June 30th, we're really encouraging everyone to update their sick leave policy. It's probably 12 weeks till Christmas. I'm not sure, 12, 13. So it's coming fast. January 1st is coming fast. So, please feel free to reach out to us if you need assistance. And thank you very much, Teresa and Jennifer, and for everyone attending. We really do appreciate your time, and we hope you find value in these. We'd love for you to take the feedback survey, and everyone have a great day. Thank you very much.